to 142 were added in 1988 with effect from 1st April 89, and section 143 to 147 were added during December 2002, and section 148 was added in 2008. Section 13, one of the important sections, there's a question in the examination. Negotiable instrument means and include promissory note, bill of exchange, and check. So it might be asked in the exam that negotiable instrument includes promissory note, bill of exchange, and check. It is declared in which section? So it is section 13 of NI Act 1881. Now let us discuss some more sections of this act. Section 4, promissory note. Now, what is a promissory note? Let us first understand what is a promissory note. It is basically an instrument in writing. It is not a bank note or a currency note, first of all, to be very clear. It is an instrument in writing, contains an conditional undertaking signed by a maker or to the order of a certain person or to the bearer of the instrument. The parties involved over here are maker and payee, and it needs to be stamped. Promissory note can be drawn like to be paid in installment, and a provision also can be made that on default of one installment, entire amount mentioned in promissory note becomes payable. These are some important features of promissory note which we need to take care. Question can be made in any form in your examination, like under which section promissory note is defined, or what is the definition of promissory note, what are the parties of promissory note, whether it needs to be stamped or not. Now, another important aspect over here is currency notes being money. Thou fulfills the condition of promissory note are not promissory notes and governed by Indian Currency Act section 21. It is a very important point. The currency notes are not promissory note. Even though they fulfill all the conditions of promissory note, they are governed by Indian Currency Act section 21. So you need to remember, a straight question can come in the examination that under which act or under which section of which act currency notes are being defined. So it is section 21 of Indian Currency Act. Now let us understand types of promissory note. So there are two types of promissory note over here: demand promissory note and usance promissory note. Demand promissory note has to be paid immediately on demand, and usance promissory note has to be paid after some time period. This needs to be taken care. So let us move to the next section of the NI Act, next important section of the NI Act, that is bill of exchange. It is defined under section 5 of NI Act. And the parties involved over here are drawer, drawee, and payee. Now let us understand the definition of bill of exchange. It is an instrument in writing containing an unconditional order signed by maker directing a certain person to pay a certain sum of money only, or to the order of certain person or to the bearer of the instrument. So I'll break this definition and explain it to you. From the point of view of the exam, this definition can be broken into various options, and a question can come कि a bill of exchange includes. So first option would be instrument in writing. So it is correct. Again, it is an unconditional order. It is also correct. It is signed by maker. It is directing a certain person to pay a certain sum of money. So this is again correct. This is an element of bill of exchange. Or it might order a certain person as well as the bearer of the instrument also. So these are the bifurcation of definition of bill of exchange. The parties involved over here are drawer, drawee, and payee. Now let us come to the another instrument, that is check, which is defined under section 6 of NI Act. Check. What is check? Check is a bill of exchange drawn on specified bank and not expressed to be payable otherwise than on demand. So if somebody demands it is okay. Otherwise, it is not paid. The parties involved again in the check are drawer, that is account holder, drawee, that is the bank account is being maintained, and the pay, the person on whose name the check has been drawn. So these are the parties to the check. Now, very important thing, the definition of check under Section 6 of NIE Act includes electronic check as well as truncated check. In December 2002, there was an amendment made in NIE Act where it included electronic form of check as well as truncated form of check during the clearing process to be defined as a check. So don't get confused over here. They might ask you a question as definition of check. I hope I am audible. Kindly confirm in chat box or by thumbs up. Okay, I am audible. If someone can just confirm in chat box. Yeah, sure. Okay, let us continue. Now, as I told you, the electronic check as well as truncated checks are included in the definition of check in Section 6. Let us discuss definition of electronic check. That can again be a question. It is an exact mirror image of a paper check, and it is returned and signed in a secure system, ensuring minimum safety standard with digital signature. So please understand, there's a difference between truncation of check and electronic check. What is happening in truncation of check during clearing? We are stopping the physical movement of check and we are electronic image of the check for transmission and for clearing. But in electronic check, we are using digital signature. So that is the key element. We are using crypto signature or biometric signature or a digital signature for that matter. So this is the difference between electronic check and a truncation of check. Now, another important aspect regarding to the date of the check. The checks without date are not payable. If a check bears a date which is a holiday, then the check can be paid. If a check bears date which is National Sakha calendar, that is Hindu calendar, it can be paid. Let's say a check bear impossible date, very important. What is impossible date? First of all, understand 31st November, 30th February. These are impossible dates. So if a check is dated like that, it can be paid on the last correct date, like last working day or the last valid date. But if I ask you that a check bears 26 January is the date, can it be paid on 25 January? It can't be paid. But if it is bearing some impossible date like 32 January, it can be paid on 31st January. I hope I am clear. This might come as an example in this example might come as a question in your examination. Next is stale check. Let us understand what is stale check. The validity period of check is expired due to date mentioned on the check, that is 3 months from the date. So a check becomes stale after the 3 months. What is revalidation? If a check becomes stale, it can be revalidated. So this is date of check. Now let us understand few more definition related to date of check. Antedated check. Antedated check is check bearing date prior to the actual date of signing of the check or prior to the opening of the account. So if a check bears a date before the account opening date or before the actual date, it can be paid till it becomes stale. Now, what is post-dated check? The date which has not yet fallen on the calendar. And if we are drawing such a check that, okay, let's say today we are sitting in January. If I draw a check of 1st March, then it is called as post-dated check. It can't be paid. Now, payment of such check is not a payment in due course and additionally poses following risk. Drawer can stop payment or deaths, insolvency, or lunacy might happen. Garnish order might also be served on such account. So we can't pay a post-dated check. What I want to make it clear over here. I hope you are clear with both the definition. Don't get confused by antedated check and post-dated check. It might come as a question in the examination ki what is an antedated check. So if a check bears date prior to the actual date, it is an antedated check. And if the date has not yet fallen, such checks are post-dated check. Be sure about that. Next section is section 8 of NI Act, which defines holder. Now, who is a holder? Any person who is entitled in his own name to possess the check and he or she is having legal right to possess the check, they are called as holder. And now section 9 defines holder in due course. The holder in due course is a person, payee, endorsee, or bearer, he might be anyone who must have the instrument in his possession. So he or she is holder in due course. Now let us understand. I used a word, payment in due course. So what is payment in due course? Please understand, this is a very important question. What all components form payment in due course? So there must be sufficient funds of the drawer available with the bank. Funds must be readily available for the payment of check, like there must not be any lien or freeze marked in the account. And there must be a proper demand for payment. Now, if we define payment in due course under section 10, it tells us it is in accordance with the apparent tenor of the instrument, like the check has not expired. As we told, 3 months is the validity period. Payment must be in good faith and without negligence. Like we all know that there must not be any cutting. Any other cutting except for the date is not acceptable. And payment must be made to the person in the possession of the instrument. Without taking instrument, we can't do the payment. And if every other condition is seen to be normal, we don't have any, any such circumstances which can be doubted upon, we can make that payment, and that is called as payment in due course under section 10 of NI Act. Let us discuss important sections pertaining to protection to the paying bank. Very important. In case of order check, section 85(1) says that protection to the paying banker would be there if everything is in order. Section 85(2) talks about protection to the paying bank in case of bearer check. And section 85(a) discuss about protection to the paying banker in case of DD. Section 89, very important again, check with material alteration not visible with the naked eye gives a protection to the paying banker. And section 128 gives protection to paying bank in case of payment of cross check, if everything else is in order. So these sections need to be taken care of. Section 85(1) for order check protection to paying bank. Section 85(2) bearer check protection to the paying bank. Section 85(a) protection to the paying bank in case of DD. Section 89 where protection to the paying bank for check with material alteration not visible with naked eye. And section 128 for payment to the cross check in case of NI Act. Now, importance of delivery, which might be actual or constructive, would be defined in section 46 of NI Act. Delivery of instrument by legal heir endorsed by deceased person considered negotiation is not complete is defined under section 57 of NI Act. So it might be asked if a delivery of the instrument is done by the legal heir in case the person is deceased and endorsed by him or her. Not endorsed by him or her rather. So it is defined under section 57 of NI Act. Now, when we talk about endorsement, what does endorsement will understand, but endorsement is defined under section 15 of NI Act. First of all, remember this. Section 15 of NI Act talks about endorsement. Endorsing means signing on the face or backside of an instrument or even a piece of paper called allonge for purpose of negotiating an instrument. Let's say a check is drawn in my name and I sign on the back and I endorse it to someone else. So that is endorsement. You all know it. It is defined under section 15 of NIA. Another question in the exam can be, what is an allonge? So in lieu of endorsing the check on the back side, a person is writing a piece of paper and doing the endorsement on that piece of paper. It is called as allonge and it is a valid thing. So please do remember what is an allonge. Okay, I thought somebody informed me the voice is breaking. So I'll repeat it again. Endorsing means signing on the face or the backside of an instrument or even on a piece of paper called allonge. So when we are endorsing on a piece of paper, it is called as allonge. And it is used for purpose of negotiation and it is a valid thing. So it might be asked, what is an allonge? So do remember. Now, the person who signs and transfers the instrument is called as endorser, and in whose favor the endorsement is done, he or she is called as endorsee. Now, yes. One more thing, as we are into webinar, you won't be able to ask your doubt verbally. Please post your queries in chat box and we would be replying that. You can post your queries, if any, in the chat box. Now, let us continue with the discussion on NI Act section 18, where amount is stated differently in figures and words. What we have to do. So if the amount undertaken or ordered to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or ordered to be paid. So the words amount would be considered. So it is defined in section 18 of NI Act. Another very important probable question. Let us now discuss type of endorsements. We have talked about what is endorsement in section 15 of NI Act. Now we'll discuss the type of endorsement. Let's say endorser only signs on the instrument without writing any instruction. It is called as blank endorsement. Okay. Endorsement in full means endorser signs his name and adds the name of endorser specifically. So suppose I am endorsing आई एम एंडोर्सिंग अ चेक, मैं किसी के फेवर में एक चेक एंडोर्स कर रहा हूं, पीछे मैं एंडोर्सी का नाम अगर ऐड कर दूं तो इट इज कॉल्ड एज फुल एंडोर्समेंट. आई हैव स्पेसिफाइड कि आई एम एंडोर्सिंग दिस चेक टू मिस्टर एक्स, मिस्टर वाई. नाउ अगर मैं चेक के पीछे आई राइट पे टू ए ओनली, और इंस्ट्रूमेंट के पीछे इफ आई राइट पे टू ए ओनली, इट इज अ रेस्ट्रिक्टिव एंडोर्समेंट. दैट मीन्स आई हैव restricted Mr. A from further endorsing that instrument. Again, there is a terminology called as conditional endorsement. That means I put a condition, he pay to A when he marries. That means I have put it a condition that if the condition that A gets married is fulfilled, then only pay to A. Then again, there is one more endorsement जिसको हम बोलते हैं partial endorsement. That means negotiable instrument पे जो amount है, the amount which is mentioned on negotiable instrument is paid in part, can be transferred in part. So this is called as partial endorsement. This is for the purpose of definition. This is not a really valid type of endorsement. Next, let us move to the another important segment of NI Act that is defined as crossing of check. Crossing is applicable first of all in checks only. It doesn't cover any bill of exchange or promissory note. Understand, there are two types of crossing defined under NI Act. First is general crossing defined under section 123. Second is special crossing defined under section 124. General crossing is defined by two parallel transverse line on the face of check without or with words such as end company, not negotiable, account pay, etc., etc. If there are two lines drawn on the face of check and some word or some name of bank is written on it, it is called as special crossing. I'll give you an example. Suppose a check is given to you. On that, two parallel lines are drawn, transverse lines are drawn, and company or account pay or something like that is written, it is called as general crossing. Suppose a transverse line is drawn, two transverse line are drawn on your check, and name of the specified banker is written like HDFC Bank, then that particular check would be payable only at HDFC Bank. You can consider example as the dividend warrant which are being issued by various companies. Sometimes they specifically mention the name of the bank where it could be payable. So this type of crossing is called as special crossing. Very important question from the point of view of the exam. What is definition of general crossing? What is definition of special crossing? And section number 123 defines general crossing. Section 124 of NI Act 1881 defines special crossing. I hope I am clear. Now let us understand general crossing and special crossing in a bit detail. General crossing involves two parallel lines. Special crossing involves name of the bank. Not negotiable crossing involves key further endorsement can't be made, and pay account crossing involve that amount would be paid to payee only. So in general crossing and special crossing, basically we are giving an instruction to or direction to paying bank who would be paying the check. And in case of not negotiable or account pay crossing, we are giving instruction to collecting bank. Next, dishonor of check. Dishonoring of checks. Section number 138 to 142 of NI Act 1881 discuss about dishonor of the check and the types of punishment given for dishonoring of the check. Listen to this section very carefully. Drawer of the check which is returned unpaid because of insufficiency of fund or stop payment of the check is deemed to have committed criminal offense under section 138 of NI Act. So if a check is returned due to insufficiency of fund or stop payment, the drawer is supposed to have done criminal offense. It is defined under section 138. Now, suppose you want to do any prosecution on the particular drawer. Okay, now I want to file a suit or file a case against such drawer. There are some prerequisites for prosecution. What are the prerequisites? Check should have been issued to discharge a liability. If suppose somebody has given you a gift, you can't, claim 138. You can't apply section 138 on that. Check must have been presented timely, like it should be a valid instrument. The payee or holder in due course should give notice demanding payment within 30 days of receiving information of dishonor. Very important. This can be a question. The holder in due course or payee will have to give a notice demanding payment within 30 days of his receiving information of dishonor, which should be for reasons such as insufficiency of fund, refer to drawer, or stop payment. Like 30 days is the key essence over here. Please do remember that the payee have to give such notice before, going for section 138. Here gives a 30 days. Payee or the holder gives 30 days demand notice before claiming the prosecution. Next. I hope the prerequisite first condition is clear. That just put your message in the chat box if it is clear. The notice period of 30 days should be given so that the dishonor before going for prosecution, if the check is dishonored for the purpose like insufficient fund, etc. Now, some other prerequisites are the drawer can make payment within 15 days of receipt of notice. Let's say I am the drawer and I got the notice within 30 days. Okay, we would be going for section 138 if you don't fulfill the condition. I am having 15 days time from the receipt of notice that I can pay the fund and stop the prosecution against me. So if I pay within 15 days of the receipt of notice, prosecution can be stopped. This can be another important question from the point of view of the exam. Now, suppose the condition is not fulfilled and section 138 is implemented. What are the punishments in it? So let us understand punishment kya kya hai. An offense is punishable with imprisonment of term which may be extended to 2 years, or with fine which extend to the twice the amount of check, or both. So 2 year imprisonment or twice the amount of check, or both. This is punishment. Now, if the offense get compounded, like it get repeated, then a fine of 5,000 and 1 year imprisonment. Fine of 1,000 and imprisonment can be given. Kindly listen very carefully. Every section can't be repeated again, so please be cautious while I'm saying. I hope the punishment is clear. I'll repeat the punishment: 2 years imprisonment or fine twice the amount of check, or both. If the offense is compounded, that means repeated, court can again impose a fine of 5,000 and 1 year imprisonment. Apart from that, the jurisdiction authority would be metropolitan magistrate at least, or judicial magistrate of first class, who can try such cases. Now, again, let me discuss or brief some important section of NI Act. Section 4 defines promissory note. Section 5 defines bill of exchange. Section 6 defines check. Section 7 defines drawer, drawee. Okay, so let us start discussion on important section, or let us summarize about the important section of NI Act. Section 4 defines, I'm again reiterating important section, so please make a proper note of it. Section 4 defines promissory note. Section 5 defines bill of exchange. Section 6 defines check definition. Section 7 talks about drawer, drawee, acceptor. Section 8 defines holder, holder in due course is defined in section 9. Payment in due course is defined in section 10. Section 15 defines about endorsement. Section 16 talks about endorsement in blank and full. Section 18 talks about amount in word and figure differs. Section 19 describes instrument payable on demand. Section 20 discusses about inchoate instrument. Section 31 discuss about honor of check. Section 47 discuss about bearer check. Section 48 discuss about order check. And section 49 discuss about conversion of blank endorsement. Section 52 discuss about sans recourse endorsement. So these are few important sections. Another important section is section 85A, where we discuss about payment of order instrument. Section 85B, where we discuss about payment of bearer instrument. Section 87, where we talk about material alteration. Section 118, where we discuss about presumptions of NI. Section 123, where we discuss about general crossing. Section 124 of NI Act, where we discuss about special crossing. Section 125 discuss about who can cross. Section 126 discuss about effect of crossing. Section 128 discuss about protection to the paying banker in case of default or in case of cross checks. Section 129 discuss about liability to true owner in case of cross check. Section 130 discuss about not negotiable crossing. Section 131 is a protection to the collecting bank. Section 138 is dishonor of a check for insufficient fund. Section 142 to 147 discuss about section related to summary trial. So these are some important sections. Now, after NI Act, we would be discussing about service to the customers or remittances. Now, here we have to understand first of all that payment and settlement system plays a vital role in improving overall economic condition of the country, and currency instrument, whether it is a currency instrument, paper instrument or check or anything which is through electronic channel, it all together comprise of a payment and settlement system. RBI over here in India is playing the pivotal role as central bank in developing the settlement and payment system. And payment and settlement in India is governed by Payment and Settlement System Act 2007, that is called as PSS Act 2007. So in India, there are three ways basically by which we are doing payment. First is via paper-based instrument. Second is via electronic instrument. And third is by the means of other instrument like mobile banking, ATM-based trans, point of sale terminals, and online transactions. Important figure. In India, still we are around 35% of our transactions are done through check. 35% of the transactions. So as I told you, my payment system in India comprises of three elements, that is paper-based, others that is your ATM, etc. And third is electronic payment system. Let us try to differentiate between both the modes like paper or cash and electronic mode, and what are the benefits of an electronic mode. So in cash or paper mode, the physical movement, as you all know, is there. Operation cost is high, time is required. If the volume increases, logistic cost also increases, and there are some geographical restrictions. But in case of electronic payment system, since the movement is electronic, it takes very less time. No logistic is required. No restriction of location is there. And the time required is curtailed down. When we talk about the other instrument, again, like mobile banking or ATM, POS transaction, again, we are saving time and operation cost. That's why we are emphasizing more on other payment system as well as electronic payment systems. So this is an important data that 35% of volume of total non-cash transaction in the country is through checks. Now, let us understand about what are electronic modes of payment available over here. First is ECS, that is Electronic Clearing Services. So in Electronic Clearing Services credit, we handle bulk and repetitive payment like salary, interest, dividend payment of corporate and other institution. It also facilitates customer account to be credited on the specified value date, and it is majorly available in all the big cities of the country. Then we talk about NECS, that is National Electronic Clearing Services. Please do remember the full form also. That might be a simple question. Many a time we presume that difficult questions would be asked, but simple questions are also asked. So do remember the full form of ECS as well as NECS. So in NECS credit facility, multiple credit to beneficiary account with destination branches across the country against a single debit of a account of sponsor bank is done. So single debit of sponsor account and multiple credits to the beneficiary across the country. On the same verge of NECS, a miniature called as RECS, which is called as Regional Electronic Clearing Service, is being started by RBI for regional collections. Again, electronic clearing service debit is a faster method of effective periodic and repetitive collection for utility companies like electricity companies or telecom companies. Here, the facility of consumer of utility company to make routine and repetitive payment by mandating the bank branches to debit their account and pass on the money to the companies. The best example is you can create a mandate in your Vyom app also for repetitive payment of your electricity bill or telephone bill. It is available in all the payment apps, in all the maximum of the payment apps. Next mode of remittance is NEFT, National Electronic Fund Transfer. Most secure one-to-one fund transfer between individual and corporate, and batch settlement of half-hourly intervals takes place over here. National Electronic Funds Transfer is settled in half-hourly intervals. And the difference between NEFT and RTGS is real-time gross settlement. What is RTGS? It is real-time gross settlement. So in real-time gross settlement, we are settling transaction on one-to-one basis. So gross settlement in itself means one-to-one settlement without bunching or netting the transaction. On the other hand, what is the difference in NEFT? It is National Electronic Fund Transfer, where the settlement is done on the basis of half-hourly intervals. The amount of half hour is clubbed and it is settled. And here in gross settlement RTGS, we are doing one-to-one settlement. So this is the difference between NEFT and RTGS. Now let us understand the role of Clearing Corporation of India Limited, that is called as CCIL, which is basically set up to provide exclusive clearing and settlement transaction in money, government security, and foreign exchanges. So if somebody asks you in examination that for clearing and settlement of transaction in money, government security, foreign exchanges, which body is looking after all these processes? So it is Clearing Corporation of India Limited. Its primary objective has been to improve efficiency in transaction settlement, debt and forex market in the country. So it deals in all the instruments, all the debt and forex market for settlement purposes. So do remember, it is Clearing Corporation of India Limited. Next, let us discuss about National Automated Clearing House, NACH. So NPCI, which is National Payment Corporation of India, offers bank, FIs and other government bodies NACH facility in case of debit and credit both. So bank, where they have to understand, suppose there is an interbank transaction to be done, which is of high volume and low value. Let's say some bank is there, let's say Union Bank has to pay dividend to all its customer. So it would be going for NACH. The debit account is in one bank, single debit, and multiple credits would be there. So NACH facility would be used. However, it is being replaced by ECS, which is a modern technology that is electronic clearing system, which we have already discussed. Again, understand what is mandate management system. It is service of NACH debit, which facilitate process of mandate creation, mandate amendment, mandate cancellation. As we discussed, other payment systems are also there, which are helping and facilitating transaction and remittances, that are mobile banking system, ATMs, POS transactions, as well as online transactions. These modes are also play a significant role in remittances. POS, please remember, point of sale. ATM is automatic teller machine. I already told you real-time gross settlement. NEFT is National Electronic Fund Transfer. This is payment services. I'm again reiterating, please do remember the full form of the abbreviations. It might come as a question. Now, let us move to another important aspect, that is Safe Deposit Vault Locker, SDV Locker. Now, first of all, let us understand banker-customer relationship in few cases. Let's say a customer is depositing some amount in bank. In that case, banker is debtor and customer is creditor. If suppose a customer has taken loan from the bank, banker is creditor and customer is debtor in this case. In case of safe deposit vault or SDV locker, the bank and the customer is licensee. Please do remember this. From past 2-3 years, it has clearly been changed in the policy. Previously, it was lesser lessee. Now it is licensor, licensee. Do remember this. This is a very important question of the examination. What is bank relationship? SDV locker. SDV is safe. First, secondly, the banker is licensor over here, and the licensee. I hope I am clearly audible. Just thumbs up if possible. If somebody can just thumbs up. Or put it in chat box. Okay, let us proceed. Okay, let's proceed. Safe custody. In case of safe custody, there is bailee and the customer is bailer. It is again important from the point of view of the exam. Let's say if bank is issuing a draft, here the bank is a debtor and customer is creditor. If bank is payee of the draft, then in that case, bank is trustee and customer is beneficiary. If we are collecting a check on behalf of customer purely to credit his or her account, then we are agent. We means bank. Bank is an agent over here and customer is principal. In case of pledge, customer is a pawner or pledger and bank is pledgee or pawnee. In case of mortgage, bank is mortgagee and customer is mortgager. In case of hypothecation, if we are creating a charge by hypothecation, bank is hypothecatee and the customer is hypothecator. If suppose a customer deposits some money in the bank without the instruction of disposal, let's say he forgot to write the name of the customer in his whose account it has to be deposited, and he deposit on the cash counter. In that case, bank is trustee and customer is beneficiary. Here, bank would not be debtor and customer would not be creditor. Do remember, here the bank would be trustee and the customer would be beneficiary. If let's say a customer left some good or article by mistake, then in that case, again, the bank would be trustee and the customer would be beneficiary. Please do remember. I hope it is clear to all of you. One question might come from this entire table. Okay, let us discuss type of locker which we are having in our bank. First is safe deposit locker cabinet, open type, and safe deposit locker, which is safe type. So with BIS standard B category strong rooms जहाँ पे होते हैं, which are installed, B labeled strong room doors, there are SDLC lockers, and where class B strong rooms are not there, or BIS class B labeled strong room doors are not installed. In such case, safe deposit locker, safe type are being installed. To remember like this. Yes, let us discuss some important facets of locker. Lockers are allotted on first come first serve basis after complying KYC. Another very important question. Branch need to maintain a register of customer, like branch need to maintain a wait list of the customer in the register on first come first serve basis, and 80% of the locker should be filled as per that waiting list. That list can also be maintained in Finacle using menu LK wait. We would be discussing few Finacle menus pertaining to locker in coming slides, but do remember this. And remaining 20% of the lockers can be allotted as per the discretion of the branch head. It is a very important question. How much locker a branch head can allocate as per his or her discretion? It is 20% maximum of the remaining lockers and 80% as per the first come first serve register or waiting list. Again, to ensure prompt payment of license fee, RBI has permitted bank to obtain a fixed deposit at the time of allotment of locker, which will cover 3-year fees and charges for breaking open in case of any eventuality. So don't take any wrong option like 50,000 FD or 20,000 FD is compulsory before giving locker. No. The FD which is suggested over here is 3-year fee plus charges for breaking open in case of any eventuality. Do remember from the point of view of the examination. Again, suppose there's some visually impaired person, the locker can also be given to them on single name also and in joint name also. So we should not force them to have a locker on joint name. They would be given key. They would not be given any assistance in operating the locker at that particular time while they are coming for operation. But if they want to avail help of a third party during operating that locker, a proper record keeping is to be done for third party. And at the time of giving locker, it is better that you can do their KYC, name, address, relationship, etc. so that confirmation can be made about the third party. And the SS of third party is at full risk of licensee. That means the locker operator. They are permitted, the licensee, the locker holder is can apply additional lock of his or her own. The cost would be borne by them only. Between two locker operation, the grill door of vault should be closed. After identification, only somebody should be allowed, like licensee should be allowed in the vault area. Operation should be permitted up to the prescribed business hour applicable for non-cash service. Another important question. A licensee will be permitted in the vault room only for a reasonable time. Now, question can be asked, what is the reasonable time permitted to the licensee in the vault room for operating locker? Not more than 30 minutes. The answer is not more than 30 minutes is the reasonable time. Now, let us understand what are the responsibility of the branches in this case. They will have to maintain KYC document. They have to get agreement signed. They have to maintain a check-in, check-out register. They have to maintain a master key register and a wait list register. Apart from that, the branches which are having lockers have to preserve CCTV camera footage for at least a period of 180 days. That is not less than 180 days. Another important question. They have to also maintain an ingress and egress register. And after every locker operation, it is suggested that the officer in charge needs to check the locker room that licensee has not left any valuables outside the locker. If the locker is surrendered and you are giving that locker again to someone, keys must be interchanged after the locker is surrendered. For that particular purpose, there is a menu in Finacle which is called as LKKM. LKKM. And once in a fortnight, branch manager must do surprise verification of surrendered or vacant lockers. Now, let me discuss few important menus pertaining to locker operation. First menu is LKACU. For operative account update, change of operative account number of the locker. If you want to change the operative account number of the locker, you can use LKACU. If you want to change CIF ID in locker, you can use menu LKCC. For transaction history maintenance and for seeing locker fees and penalty collection date, etc., the menu which can be used is LKCHM. For customer maintenance like issuing the locker, operating account, surrendering the locker, you can use the menu LKCM. For maintaining key, like for adding new key, for modifying existing key after surrender, for deleting some old key, and for inquiring key number, you can use menu LKKM. For maintaining the operations like check-in and check-out entry in the Finacle, you can use menu LKOPS. For charge like fees as well as penalty, there are two parts of charges, fees and penalty. The menu which can be used is LKRCM. For generation of various types of reports like overdue fees, vacant lockers, the menu which can be used is LKREPM. For type and fee maintenance, that is checking locker fees as per their type over the period of time, we can use menu LKTR. For license fees updation or locker fees updation in Finacle, the menu which can be used is LKUPL. And for waiting list, like maintenance of waiting list, like adding new customer in the wait list of the branch, the menu can be used is LKWAIT. So these are few important Finacle menus for doing locker operations. Now, let us discuss some more important aspect about locker license fees. Annual fees depends on size of locker and branch type like semi-urban, urban, metro. License for the locker is given for a minimum period of 1 year and maximum period of 3 years at the time of subject to advance payment of fees. Locker fee we have to collect in advance annually and up to an extent of maximum 3 years advance can be collected. Even if somebody is paying 3 year advance fee, no concession is given. If the fee gets overdue, penal interest of 18% is being charged. Locker can be operated n number of times, but the free operation is restricted to 12 per annum. Very important question. That the free operation allowed inside the locker is 12 per annum. After that, every operation is chargeable. And charge is 100 plus 18, 118 rupees. And the system will understand that more than 12 transaction in the locker is being done if we are maintaining the entry and exit properly using LKOPS menu. So LKOPS menu will play a significant role in helping the bank to collect non-interest income in case of operation more than 12 per annum. Let us discuss about the nomination facility in case of locker. If somebody don't want to nominate anyone, they can give an undertaking that I don't want to make any nomination. Nomination can be done in favor of a single person if the locker is in single name. And if the locker is in joint name, one or more person can be nominated. If the locker is in joint name, nominee will have to access the locker and receive its content jointly with the surviving locker holder. Suppose A and B are locker holder and let's say A dies. So the nominee along with B will have to receive the content of the locker by operating the locker jointly. Please do remember this. This can be a probable question. Some case study might be given of 2 lines and it might be asking who will be the final beneficiary of the locker content. Okay. Resident customer can nominate non-resident relative as nominee. A non-resident nominee cannot seek repatriation although. Like suppose some article or fund is there inside the India, they can't repatriate the same to outside India. A non-resident locker holder may nominate a resident or non-resident as nominee. Exchange control approval is required. Very important. Exchange control approval is required. Suppose if NRI nominee or non-resident nominee want to take the content of locker outside the India. Suppose you are nominating any non-resident person as nominee in the locker. Please do take additional particulars like passport number and country, or like residential status of that particular person. Now, what are extra facility given to the staff member in case of locker? They are allowed non-resident nominee in case of non-resident nominee. First of all, understand exchange control approval will be required. If the content are to be taken outside the India, exchange control approval would be required. Otherwise, no repatriation is allowed until and unless exchange control approval is there. Apart from that, if somebody is a non-resident nominee, additional details like passport number and country of the non-resident nominee has to be taken in the form while nominating. And the staff members are getting some extra facility in case of locker, like 25% concession in licensee fee or locker charges, One staff can have maximum 2 lockers in his or her own name or jointly with the family members. A letter of authority issued by staff member allowing operation of locker by a person other than his or her close relatives should not be accepted. Very important. No security deposit is required for staff or retired staff. Only current year locker fee would be collected in advance for the locker given to the staff. Penalty for late payment of fee and service charges of operation of the locker in excess of 12 times the year is to be collected from staff or retired staff. Now let us understand rights and duties of licensee. A licensee is bound to keep and on termination of hiring to restore the locker in as good condition. A licensee is bound to allow bank official at all reasonable time during the term to inspect the condition of locker and give any notice of defect. On termination of license agreement, licensee is bound to put the bank into possession of locker along with the key surrendering. They can't transfer or assign or sublet the locker, very important. And if there is any change in address, they have to notify the bank in such cases. Now let us discuss some important aspects about break open of the locker. Bank has right to break open the locker and deal with the circumstances. Suppose bank is having a right to terminate the agreement and licensing granted hereunder after issuing customer a prior notice of not less than 3 months. Important question. Suppose there is some breach of contract from the point of view of the customer, or they are not cooperating or complying to any term, and bank want to terminate the agreement. In that case, bank will have to issue a prior notice of 3 months at least. Very important question. 3 months notice has to be given before breaching the or before terminating the agreement from the bank side. Apart from that, what are the conditions where bank will go for break open of the locker? Suppose let's say rent is unpaid for 3 consecutive years, or locker is inoperative for a period of 7 years or more. Very important. Customer cannot be located even if the rent is paid, but the locker is inoperative for the period of 7 years or more. The bank will go for break open of the locker. Very important. First condition, rent remain unpaid for 3 years, consecutive years, and locker is inoperative for a period of 7 years or more. Very important. Now, what is the procedure of issue of notice? We'll discuss in brief from the point of view of the exam and what questions are there. 15-day intimation of locker rent due would be first given. Then some termination notice would be given. And 3-month time would be given after the termination notice. A 3-month notice would be given. Notice must be given through registered post and acknowledgement must be kept on record. If joint locker holders are there, you have to give notice to each individual holder. Apart from that, an additional notice of 3 months is again given. And in absence of acknowledgement, two newspaper, one is in English language and one is in local language. In absence of acknowledgement, notice has to be given in minimum 2 newspaper. One is in English language, another is in local language. Then bank has to intimate locker holder through notice to collect article found, if any, by paying the dues. And before the sale of the content, a notice of not less than 3 months in writing to be given to locker holder. Suppose now you break open the locker, now you've taken out the content. Again, if some content is there and you want to recover your rent by selling those content as a bank, you have to give at least a 3-month notice to the locker holder. Do remember this point. Now, let us understand some procedure of death claim settlement in various scenarios. In the event of death of sole locker hirer or licensee, if nomination is given, no problem, give the content to nominee. If it is not given, legal heirs will come in picture, claim settlement would be done to them, and bank will make an inventory list. Let's say in the event of death of locker hirer or hirers for jointly operated account. If the nomination is given, please give the content to survivor as well as nominee jointly. Okay, and if no nomination is given, claim settlement will be done with legal heirs of the deceased as well as survivor jointly. In case if locker is having a mandate, either survivor, anyone survivor, former survivor, then whatever they have given as a mandate at the time of hiring of the locker would be followed. Now, after locker, let us discuss about death claim settlement procedure of locker. Bank settled the claim. Let's say bank has received some death claim in case of locker. The timeline is maximum of 15 days from the receipt of claim. But 15 days from the receipt of all the documents of the claim, like production of death proof, production of suitable identification of claimant, and bank is satisfied. Then 15 days from receipt of claim, bank has to settle that claim. Bank should have a copy of death certificate, and branch manager, if he or she is personally aware about the death of the customer, they can waive this death proof requirement. Okay, so this is procedure of death claim settlement in case of, specifically in case of locker. Now we would be discussing about death claim settlement procedure of normal nomination and death claim. Up till now, we were discussing about the procedure of nomination and death claim in case of locker. Now, another important question from the point of view of the examination. Under which act and which section? 45ZA to Banking Regulation Act 1949 talks about nomination. This question has come in past in examination. So for deposit account, 45ZA, 45ZB are the sections. For safe deposit vault, that is locker, section 45ZD, 45ZF. And for safe custody article, section 45ZC, 45ZD. So it is important, please do remember these sections. Accounts which are not eligible for nomination are minor self-operated account and account in representative capacity like partnership, company, HUF, trust. Another important question. What is the status of nominee in case of receiving proceeds of death claim? Nominee is always a trustee of legal heirs. Do remember this line. What is the status of nominee in case of any death claim settlement? It might be in case of locker, it might be in any other case. The status of nominee is trustee of legal heir. The examiner will ask you some questions like nominee is having status. Options should be equivalent to the account holder, equivalent to the joint account holder. But don't get confused. The answer is straight. Trustee of the legal heir. Trustee of the legal heir. Okay. Now let us discuss how many nominee can be there. Obviously, in case of deposit and safe custody account, only one nominee is allowed. Straightforward answer. In case of deposit and safe custody, only one nominee is allowed. But in case of SDV lockers, like in case of single holding, one nominee is allowed. But in case of joint nominee, joint holders can nominate individual nominees. Here it is not written, but I think it is subject to maximum of 2. Now, what are the methods of claim settlement? First is very simple, pay to the nominee if nominee is given. Second is pay to the legal heir on production of legal representation. And third is pay to the legal heir in absence of legal representation. So these are the 3 modes by which a death claim is settled. Now we'll discuss them one by one. First is payment to the nominee. Let's say nominee is declared in the account or locker and we have to settle the death claim. So what will take? Documents, application form, original death certificate. We'll verify any outstanding loan is there or not. Then we'll verify the nomination from account opening form. We'll verify the name of the nominee in nomination form, account, and documents provided by the nominee as per KYC norms. Then we'll ask for surrender of unused check, etc., etc. Okay. Or here, very important, we don't need any indemnity bond or surety in such cases. But one thing which we need to take care is we have to make payment through account pay check or pay order only. And we should get receipt or acknowledgement in case we are doing a payment to the nominee. Now, very important thing, and some questions can be formed from here from the point of view of the examination. Part 2 of death claim settlement, that is payment to the legal heir on production of legal representation. Suppose, what is a legal representation? First of all, understand. Legal representation, in other words, means court order. So court order can be a probated will, can be a letter of administration, and can be a succession certificate. First question, which of the following is not a part of court order? So remember, probated will, letter of administration, as well as succession certificate, all are part of court order. These are forms of court order. So bank is supposed to make payment on the representation basis of court order. Now let us understand what are these terminologies. First of all, probated will. It is a court order, but what does it says? It is basically a copy of will certified under seal of court of competent jurisdiction, confirming that the will has been executed duly and has the force to be acted upon. Bank to act as per probate or court order. So basically, probated will is a copy of certified will by the court. It is a copy of certified will by the court with its seal. And that will has been examined by the court that it has been duly executed and it is in force. So this is probated will. Next is administration letter. That is letter of administration. Where there is no will and person dies without leaving a will or appointing an executor, in such case, if an executor appointed by will is legally incapable or refused to act or had died before testator, then letter of administration will come into picture. So suppose there is no will, person has left a will, but there is no executor mentioned in the will. And third case, the executor is not interested in executing the will, or rather he is legally incapable of executing the will. In all the cases, letter of administration will come into the picture. So understand the condition where letter of administration will come into the picture. And letter of administration can be administrator can be appointed by a competent court. And it is different from an executor who is appointed by the person by his will or codicil. So executor is appointed by the person who is creating the will, and administrator is appointed by the competent court. This question has come in past. Who is an administrator? So he or she is appointed by the competent court, and who is an executor? Appointed by the person by his will or codicil. I hope letter of administration and terminologies are clear to all of you. Next, succession certificate. It is a certificate or order issued by a competent court under their jurisdiction, which declares the name of legal heirs of deceased person and percentage of their share in property of the deceased. So suppose somebody asks you a certificate is given by some customer by the, like they have brought it from the court, and the certificate mentions the share of the property of individual successor. That certificate is named as succession certificate. Please do understand the difference between letter of administration and succession certificate. Now, let us understand few more important questions. Now, suppose there is no legal representation. In case of absence of legal representation, we have to make payment to legal heirs. Suppose depositor dies without leaving any will. So what is intestate? Remember this word. What is intestate? Person dying without leaving any will behind. The person is called as intestate. This can be a question. Again, the legal representation would be required in case of no nomination, no court order. So in such cases, branch faces hardship. Now, let us understand there is a web-based portal for expeditious settlement of death claim, where saving current term deposit claims for the individual can be settled. It is first of its kind in the industry. And a dedicated email ID is there for queries, suggestion, and feedback related to web-based portal on death claim. The mail ID is dcportal@unionbankofindia.bank. Many a times people are asking questions pertaining to mail IDs of some or the other portal. So do remember this for any dedicated, what is the dedicated mail ID for web-based death claim settlement portal in Union Bank? It is dcportal@unionbankofindia.bank. I hope I am very much clear. Please do acknowledge. Again, when we are trying to settle the death claim online, the links and URLs are given on your screen. You can find that in UBI Net. This is the path which is given. And there are two different paths for claimant. A link is given, and for bank, again, for settlement of death claim, to upload the documents from the bank side, the link is given or URL is given. The login credential for claimant is mobile number or email, and it is OTP based, obviously. Now, important section. How our claim settlement procedure has been bifurcated in case of absence of legal representation. So in case of absence of legal representation, our claim settlement procedure has been bifurcated in three parts. First will include claim up to and inclusive of 5,000. Second is above 5,000 and up to 50,000 inclusive. And third is above 50,000. So in case we are trying to settle a claim up to 5,000, then if the branch manager is fully satisfied with the integrity and bona fide of the claimant, with the due inquiry whichever he has made, he can settle the claim in his capacity without insisting for legal heir affidavit or indemnity bond. Simply he'll take a declaration which is given in circular number 4698. He'll take a death certificate from the appropriate authority and a declaration from the legal heir, and then he can settle a claim up to 5,000. It is on the discretion of branch head. Now, in the case where the claim is to be settled between the amount more than 5,000 and up to 50,000, then we have to take a state claim for the policy. We have to take original death certificate. Legal heir certificate over here is not mandatory, but affidavit we have to take where they will specify that the deceased has died intestate. There is no legal heir or no will present as per local law from the deceased side. Affidavit will be executed by a notary, magistrate, office, or any other officer authorized by state government. Then again, there are two bifurcation in claim settlement. If the amount is above 5,000 and up to 25,000, let's say 24,999, a letter of indemnity will be obtained and executed by all legal heirs along with two sureties. And if the claim is about 25,000 and up to 50,000, indemnity bond has to be taken by all legal heirs and two sureties. So please do understand answer of this question. In exam, I am asking you one question. Let's say there is a death claim which is coming to me for settlement. The amount lies somewhere between 5,001 and between 24,999. What are the documents that would be taken compulsorily? So it is letter of indemnity executed by all legal heirs with two surety. And the same questions come with the amount, let's say 25,001 rupee. Then in that case, we would be taking an indemnity bond. So there is a difference between letter of indemnity, which is to be taken from 5,001 to 24,999, and indemnity bond with the signs of all legal heirs and two sureties in case of amount about 25,000 and up to 50,000. So these can be probable questions in this particular slide. Now let's say we are into the procedure of settling a claim above 50,000. Here again, we would be taking a estate claim form and original death certificate, legal heir certificate from revenue authorities, affidavit duly notarized as per local stamp act, an indemnity bond again executed by notary, magistrate or non-judicial stamp paper, and additional document in case of absence of legal heir certificate would be a declaration from two respectable person well known to the deceased family. No need to be notarized, but then again that needs to be stamped. So these are the documents. These documents you can see on your screen. Again, if one question can come from this, what are the documents required? For amount up to 5,000, you need only application form and Annexure 2 and a draft of declaration. Up to 25,000, you need application form, affidavit, letter of indemnity, and declaration. For up to 50,000 claim, you need application form, affidavit, indemnity bond with two sureties stamped or notarized, and a declaration which is not notarized. And if the claim is about 50,000, then application form, affidavit, indemnity bond with two sureties stamped and notarized, and a declaration which is again not necessarily to be notarized, but it is supposed to be stamped. Again, Very important question. Death claim policy for missing person. So if a person is missing, in that case, if I want to settle a death claim, on completion of 7 years from date of filing the FIR, obtain a non-traceability certificate from the concerned police authority where FIR was filed, and then death claim can be settled. So exam question can be on completion of how many years of filing of FIR, a person can be declared as non-traceable. So it is after completion of 7 years from date of filing of FIR, not date of missing. It is 7 years from date of filing of FIR. A person is competent enough to be declared as non-traceable. That too by the concerned police authority who have filed a FIR for the same case. Okay, it is a very important question. Do remember this, 7 years from date of filing of FIR. Now, again, when we proceed further and we talk about the death claim settlement in case of partnership account, let's say the partnership is dissolved upon death of the partner. So let's say partnership is dissolved on the death of the partner, the account operation will be stopped and balance would be paid to whom? Surviving partner plus legal heir of deceased person. Case 1. In partnership deed, it was already mentioned that it will dissolve if any of the partner dies. So the remaining amount would be paid to the living partners, like surviving partners, along with the legal heir of the deceased partners. And if the partnership is not dissolved on the death of the partner, then surviving partner might continue to operate the account. These are the two cases in case of partnership account. Another important aspect, what is the interest payable on term deposit in deceased account? So in case of death of the depositor before the date of maturity of the deposit, very important, before the death of depositor, before the date of the maturity of the deposit, the amount of the deposit is claimed after the date of maturity, then bank shall pay interest at contracted rate till date of maturity, and after that they will pay saving rate of interest. Let's say a deposit is getting matured on 1st January 2025. A customer dies on 1st December 2024 and claimant come on 1st February 2025. So till 1st December, from 1st December 2024 to 1st January 2025, amount would be paid at same rate, contracted rate of the FD. But on 1st January 2025, the FD got matured. From 2nd January till 31st January 25, since the nominee came on 1st February, the amount would be paid at saving rate of interest. Do remember this. This is very important. Again, proceeding to the next point, if the amount deposited is claimed before the date of maturity. In same example, if somebody comes, the person died on 1st December 2024, somebody comes for withdrawal or nominee comes for the withdrawal on, let's say 30th December 2024, before the maturity, which was supposed to happen on 1st January 2025, bank will pay the interest on contracted rate till date the amount is kept without any penalty. No penalty would be charged or deducted. However, in case of death of deposit after maturity of overdue deposit, bank will use policy on bank deposit and pay the interest. Now, suppose a death certificate is issued outside India. Keep some precaution. It should be verified by branch. It should be notarized by public notary. It should be apostilled and it should be consularized. Remember this 4 facets. It can be a question in the examination. What are the precautions which are necessary for death certificate issued outside India? First is branch verification. Second is public notary. Third is apostille document. Fourth is consularized document. Additional guideline, we have to take notary public of that particular country, Indian embassy certificate, banks, foreign offices there. If in any country, we can cross verify. Death certificate should be accompanied by evidence of settlement of insurance claim in foreign center, as well as evidence of settlement of proceed of bank account at foreign center. So in death certificate, it should be mentioned that what insurance claims they have claimed in foreign and what bank account settlement has been done in foreign. So it should mention both. The death certificate should comprise of both the documents. Now, another important question. Suppose all papers are submitted to the branch manager and everything is in order and the delegation is of branch manager for death claim settlement. The TAT is of 2 days at most. 2 days. And in case the death claim is beyond the delegation of branch head and the proposal is supposed to be routed to regional office or FGM office or central office for that matter, the TAT is of 15 days. Do remember this, 15 days and 2 days. Branch manager delegation 2 days, higher delegation 15 days. Again, branches have to submit a quarterly report on death claim settlement after every quarter, which ends in March, June, September, December, to respective regional offices by the 10th day of the quarter closing, like on before 10th April, before 10th July, before 10th October, and before 10th January. And regional office should compile the same and forward it to central office by 15th of the month following the end of the relevant quarter. Do remember this. Important point, very important points. Please do remember. Section 108 of Indian Evidence Act 1872 provides that presumption of death can be raised only after period of 7 years from person reported missing before the competent court. This question I have already discussed. 7 years. Section 108 Indian Evidence Act missing. Person missing. Another important thing, Banking Regulation Act 1949 was amended in 1984 and Section 45ZA to 45ZF defines nomination. Let's say I'm briefing you all the things. We are basically briefing all the things which we have discussed till now. Suppose Mr. X is the sole depositor and Mr. Y, his nominee, has died in a car accident. The deposit will now be payable to whom? It would be payable to legal heir of X. Suppose a locker is hired in name of A, B, C jointly. Now A and B came to nominate D and E as nominees. No nomination would be done or changed until and unless all three of them will come together, A, B, C. Suppose now there is a deposit account in name of A and B and the instruction is either survivor and nominee is X. Now A dies. What will happen? The outstanding amount would be paid to B in case the maturity is already done. Deposit is already matured. But if the deposit is not yet matured and you want to do a premature withdrawal, in that case, the amount would be paid to legal heir of A and B. Now, let's say there is again a deposit account in name of A and B with the either survivor mandate and nominee is X and both A and B die. What will do? Will straight away pay to nominee, that is X. Next, suppose a deposit account is in name of A and B and it is jointly mandated. And now A dies. What will be done? So the deposit would not be paid to X now because B is the survivor. But the instruction is jointly. So we'll be paying it to jointly to B as well as legal heir of A jointly. Now again in next case A and B have jointly had a SDB locker where X is nominee and A dies. Then the content would be taken by whom? The content would be taken by B and X both. Since X was nominee, here the surviving heirer as well as nominee are having a joint right for the contents. So they will take contents together. Again, let's say A and B, as I told you, maximum nomination in case of locker can be 2 previously. Let's say A and B hire a locker and X and Y both are nominee in that case and A dies. Then the content would be delivered jointly to all three, B, X and Y. Now, A locker is hired by A and B now with mandate either survivor and no nomination is given. Then on death of A, B can easily, access the locker and is having liberty to remove the content. Now, what is the status of nominee? As I told you previously also, this I'm repeating for the third time. In event of the death of debtor, the status of nominee is as good as trustee of legal hire. Trustee of legal hire. Nomination can be made in favor of minor, but at that time you have to take a name of declaration of a person that is appointee who is a major and will take care of the amount on behalf of nominee if the death of account holder happens during the tenure that the minor remains minor. In that case, appointee is required. Okay, so that was in brief some important points about NI Act, nomination, death claim settlement. Now, let us start a brief discussion, some MCQs. We would be revising the entire session by mean of some MCQs, and you would be posting your responses in the chat box. I'm sharing some questions with you. We would be discussing certainly those questions. Please do share your responses in the chat box. Okay. My first question to you is, under which section of NI Act 1881 check is defined? Please post your responses. Please do respond. Take your time, respond. No, some are writing E, 6 is correct answer. Good. D. Okay. So D is the correct answer. Under section 6 of NI Act 1881, we are defining check. Next question. Which section of NI Act 1881 provide protection to the banker against conversion? Protection to the banker against conversion is defined under which section? Please do check it. Okay, I am receiving few response. 131, some are writing C, that is 137. I don't think it is correct. 129, 131, we are receiving a number of responses. The correct answer over here is option B, that is section 131. Section 131 of NI Act 1881 provide protection to the banker against conversion. Please do remember this. Okay. Let us move to the third question. Under which section of NI Act 1881 holder in due course is defined? I expect some more answers. Only 10-12 people are responding. I'll give you more time if you want. Please do respond. Take your time. Okay, I'm showing you the options. A option is section 3, B option is section 7, C option is section 9, D option is section 20, and E option is section 11. So under which section of NI Act 1881 holder in due course is being defined? Very good. Some of you are writing other explanations also, like somebody has written section 8 is holder. Okay. Okay. Most of the people are responding as section 9. Okay. So you all are correct. Holder in due course is defined under section 9 of NI Act 1881. Okay. Let us proceed to the next question. Under which section of NI Act 1881 general crossing is being defined? Here are the options on your screen. Now I'll wait for some more time. I expect answer from each and every individual who is attending the webinar. So it would be a good revision for all of you. Okay. Still people are responding. I'll wait for them to respond. Somebody is writing, sir, I cannot see. I think most of you have seen in 2-3 screens. Most of you would be able to see this. Please do re-log in. I'll request. Anay has posted that he cannot see. Please do re-login. I request you to re-login. Okay. 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 So general crossing is defined under which section? It is answer A, section number 123. What is general crossing? I'll repeat it. General crossing is basically two traverse line drawn on a particular check, and it doesn't define any particular bank, or it doesn't allocate the instrument to a particular or specific bank. It can be a non-negotiable crossing. It can be account pay crossing. So it is a general crossing. Now, next question. A check bears name of a particular bank to whom, like where it is payable. So which type of crossing is this? Suppose I have given you a check and it is bearing a name of check, name of bank. What type of crossing is this? It is special crossing. Yes. Somebody is asking, can we get previous year papers and MCQs? Many MCQs are being uploaded. All this material and MCQs are being uploaded on Union Vidya portal. Let me just take a minute, and I just want to share a critical information to all of you. Everything is webinar we are taking over here on any topic. It is being uploaded on Union Vidya portal. Union Vidya is easily accessible to all of you on your desktops, on your laptops, and on your mobile via an app of Union Vidya. There you can find all the promotion reading material, promotion MCQs, promotion related PPTs, webinar related PPTs readily available. So you can download each and every topic from there. Okay, so do please install that Union Vidya app. Any which way, coming back to our original topic, the check bears name of the bank. Which type of crossing is this? So here it would be a special crossing. This is special crossing. Next, which section of NI Act 1881 provide protection to the paying banker in case of bearer check? In case of bearer check, which section provides paying banker the protection? So it is section. No. Somebody is writing section 131. It is not section 131, I presume. It is section 85.2. Section 85.2 provides protection to the paying banker in case of bearer check. Section 85.2 provides protection to the paying banker in case of bearer check. Okay, let us move to the next question. I again request all of you to respond. Still many are not responding. Okay, I'll proceed. Now, which section of NI Act 1881 discuss about inchoate instrument or defines inchoate instrument? Which section of NI Act? Now I'll wait for all to respond. Sorry. I'll wait for all to respond. Still many are to respond. Please do respond. Which section defined about inchoate instrument? First of all, let me explain what is an inchoate instrument. It is basically an incomplete instrument. Or some information is missing from that particular instrument. It is defined as inchoate instrument. So I presume most of you might have responded. What is the answer? Please do respond. What is the correct answer as per you? Please do respond. Inchoate instruments are defined under section 20 of NI Act 1881. Most of you have responded correctly. Neha madam has responded section 9. No, Neha madam, please update yourself. It is section 20. Section 20 of NI Act 1881 describes inchoate instrument. Inchoate means incomplete sort of instruments. Now again the same question is repeated. Okay, let it be. In which section of NI Act 1881 liability of the drawer to pay where drawer has sufficient fund in drawee's hand defined? Liability of the drawee to pay where drawer has sufficient fund in drawee's hand defined. So liability of drawee is defined in which section? To simplify the question. Some are writing section 31, some are writing section 18. Section 31. The correct answer is not D. It is section 31. Liability of drawee to pay where drawer has sufficient fund in drawee's hand is defined under section 31 of NI Act. Section 31 of NI Act. Now, which section of NI Act 1881 talks about blank and in full endorsement? Which section describes blank and in full endorsement? Okay, many are writing section 16. Few are having a different opinion. Section 15. It is discussed. It is section 16. Blank and in full endorsement is defined in section 16 of NI Act. Section 16. Please do update yourself. It is section 16. Blank and in full endorsement is being defined in section 16 of NI Act. Now, let us come to the next part. It is which section of NI Act describes endorsements? Which section of NI Act talks about endorsements? Okay, some are writing 15, some are writing 10 as the answer. Endorsement is being talked in which section? Section 15, some are responding section 10. I request all to respond. Section 15. Endorsement is being discussed in section 15. Section 15 discuss about endorsement. Section 15 of NI Act 1881. Now, read a statement that the endorser waives their liability for the completion of the endorsement. Identify the type of endorsement. The endorser waives their liability for completion of the endorsement. What type of endorsement is this? Facultative, restrictive, partial, conditional, or sans recourse? The endorser waives their liability for completion of the endorsement. What type of endorsement is this? Facultative, restrictive, partial, conditional, or sans recourse? Like it is talking that suppose somebody has endorsed an instrument, and in that endorsement they are clearly mentioning it that now there is no liability from my side. I am just endorsing it and I am not responsible or accountable for if anything happens to this instrument or it gets cancelled or something like that. So where endorser waives their liability or discharge themselves from the responsibility, such type of endorsements are called as sans recourse endorsement. I'm again repeating, please do remember the keywords from the point of view of the examination, where the endorser waives their liability for the completion of the endorsement. Like after endorsing this, they are not responsible for that particular instrument. Such type of endorsements are called as sans recourse endorsement. It is not a facultative endorsement. Some people are writing facultative or partial. No, it is wherever the liability of the endorsee gets of the endorser, sorry, gets cancelled, It is sans recourse endorsement. Next question is an underwriting where the endorser defers some privilege to which he is entitled. Suppose somebody is having, endorser is having some privilege which he is ready to give away. For instance, the endorsee is subject to pull out of disrespect to the endorser, and typically inability to pull out will vindicate the endorser from his risk. The above instance is an example of which type of endorsement. Suppose, like I am having as an endorser some privilege and I don't want to take that privilege. I give away such privileges. It might be in any form. Then what would be the type of endorsement called? Whether it would be a facultative endorsement, whether it would be a restrictive endorsement, whether it would be a partial endorsement, whether it would be a conditional endorsement, or whether it would be a sans recourse endorsement. Like basically, do remember this: ki you are having some privilege, but you are leaving it. The endorser is having some, endorsee is having some privilege, and they are not executing that privilege. Such type of endorsement are called as facultative endorsement, not conditional endorsement. Somebody has posted conditional. No, it is not a conditional endorsement. It is a facultative endorsement. Facultative endorsement. So here the keywords which are to be remembered is deferring of some privilege to which the endorsee is entitled. You are the endorser. Let's say you are the endorser. You are having some privilege, but you are giving it away, deferring it away. Then in such case, the endorsement is facultative endorsement. As an example is given over here, that endorsee is subject to pull out of disrespect to the endorser, and typically inability to pull out will vindicate the endorser from his risk. So in such cases, the endorser is deferring some of his privilege, or like taking some risk on behalf of the other. This type of endorsement is known as facultative endorsement. Now again, this is some needs to, you need to remember, each and every individual need to remember. Section 17 of NI Act defined. Question can come in this form also. This would be little bit tough. You have to make a guess. Let's see the option. Section 17 of NI Act defines what? Compensation, restriction, endorsement, exceptions, violations. What is defined under Section 17 of NI Act? Please do respond. Okay, some people are writing endorsements, only 3 responses. Okay, 7 responses. I presume all 100 to 15 to respond. I expect response from all of you. Compensation. Somebody has written, Mayank has written compensation. Yes, you are correct, Mayank. It is compensation. It is not endorsement. Section 17 doesn't talk about endorsement. Endorsement we have studied, na? It has been discussed in which section? 10. Section 17 is all about compensation. Section 17 discuss about compensation. Now, another important and a easy question rather. Section 138 of NI Act 1881 discuss about. Section 138 of NI Act discuss about. Please do respond. Dishonor of check, option A. Option B, restriction on endorsement. Option C, exceptions. Option D, violations. And option E, honor of check. Okay, this is a simple question. I hope everyone will respond to it. It is dishonor of check. So section 138 of NI Act talks about dishonor of checks. Okay, next. Account pay crossing is defined under which section of NI Act? This again might be an important question. Under which section of NI Act we are discussing about account pay crossing? Okay, I'm receiving a few responses. Only 2 responses I have received. I expect few more responses. Yes, yes. Few more to respond. Please respond. All of you respond. No. Many wrong responses are being received. Don't worry. It is neither section 11 nor section 22. Some of them are responding 124. 124, sir. Sandeep, sir, it is not an option even. So 11, 22, 33, 40, any section. It is not defined in any section. Correct answer is account pay crossing is not defined in NI Act. It is a practice. It's not a law. It is a practice. So it is not defined under any section of NI Act. Please do remember, it is not defined under any section of NI Act. It is a practice. It is not a law. Do remember this. Next question. The cases when a bank is not duly required to pay the check may be. In which of the following cases bank need not require to pay the due check? Check is not properly drawn. Payment is not demanded within banking hour. Payment is countermanded by the drawer. And bank is informed about the death, insolvency or insanity of the drawer. In which of the following case bank doesn't require to pay or bank is not bound to pay? Okay. Many responses I have received. Please other also respond. Sandeep, you are responding. Check is not properly drawn. You are correct, my dear friend, but you are not completely correct. In all the above mentioned condition, like if the check is not properly drawn, if the payment is not demanded in banking hour, if the payment is countermanded by the drawer, or a bank is informed about the death, insolvency, or insanity of the drawer, in all the cases, bank is not required to pay the check. So the correct answer is E, all of the above. Okay, in all of the above cases, Sandeep, please do make a note. In all of the above cases, bank is not duly required to pay the check. Okay, let us move to the next part. What does payment in due course means? What does payment in due course means? If the payment is in accordance with the apparent tenor of the instrument, if the payment is done in good faith and without negligence, the correct answer is all of the above. So even if the payment is done in the apparent tenor of the instrument, in good faith, without negligence, if the payment is done to the person who is possessing the instrument, and in such circumstances, you are not having any reasonable ground to doubt any other person who is receiving the payment. In all the cases, if you are doing the payment, it is considered as payment in due course. Tenor is correct. It is done in good faith. No negligence is done from the part of banker. Person is having the instrument, and there are no reasonable, grounds for making any doubts on the person bringing the instrument. So all this situation together club and form payment in due course. Now, what is a stale check? What is the definition of a stale check? What is a stale check? A check 3 months after date of its issue if nothing is mentioned about the validity. A check 1 month after the date of its issue if nothing is mentioned about the validity. So basically, this is a simple question. A check 3 months after the date of its issue, if nothing is mentioned about the validity, it becomes a stale check. Okay, next question. A check is torn into two or more pieces. It would be called as a check is torn into two or more pieces. Then it would be called as option stale check, old check, useless check, rejected check, or mutilated check. A check is torn in two pieces. What type of check is it? Okay, I am receiving few responses. What type of check it is? I presume it is a mutilated check. So the correct answer over here is E, which means mutilated check. I hope the mutilated check definition is clear to all of you. I presume all of you are aware about the mutilated check definition. Okay. So let us proceed further. Explain the meaning of bank is acting as holder for value. So in this case, where bank is acting as holder for value, suppose first option is when the bank purchased or discounted the check, except checks against OD has already allowed withdrawal against check. When the check is collected on behalf of the customer and the bank has no interest on the check, he first collect the amount and then give credit to the customer. So in which case bank is acting as holder for value? Kindly confirm. In which of the following cases bank is acting as holder for the value? In which of the following cases bank is acting as value? Please do respond. I'm again not receiving all the responses. All the participants should respond. Okay. Okay. D, B, A, N number of responses I am receiving. The correct answer is A. When the bank purchased or discount the check except check against OD has already allowed withdrawal against the check, in that case, bank would be considered as acting as holder for value. Okay. Holder for value का purpose you do understand. Holder for value means कि bank has already given the payment and then bank want to just collect its payment and settle its account. In second case, why B? Understand, please, very important. Why B is not the correct answer? In B, read the line B again. When the check is collected on behalf of customer and bank has no interest on the check, he first collect the amount and then give credit to the customer. Here bank is acting as what? Agent. Please do remember here in point B, bank is acting as an agent, and in point A, bank is acting as holder for value. Very important question. Where we are collecting some check against amount already withdrawn by the customer, then we are holder for the value because we have already paid to the customer. But in case where we are having no interest, we are just supposed to collect the check and credit it to the customer's account. It might be saving or current account. In this case, we are just acting as holder for value. I hope it is clear to all of you the difference between holder for value and as an agent, because bank acts as both agent as value. Next, bank collect a check for a person who has no title or defective title. He can be held guilty for. Bank is collecting a check on behalf of a person having defective title. Then in such case, the person, they can be held guilty of what? Change, reversion, mutilation, conversion, omission. Only three responses I have received. Okay, conversion is correct option over here. So if a bank collects the check of a person for a person who has defective title or no title rather, then the person can be held guilty of conversion. Section 131 defines conversion. We have already discussed. No, E is not the correct answer. Omission. So, Mayank, you have written omission. It is not the correct answer. It is omission. Sorry, it is conversion. It is not omission. It is conversion. I'm sorry. Which of the following is correct pertaining to collection of the check? Good faith means not having any mala fide or fraud intention. Without negligence means with reasonable care, must raise a doubt if circumstances so warrant. No alteration other than date in the body of check is allowed. And for any change in pay's name, amount in figures or what, customer should be advised to use a fresh check leave. Which of the following is correct pertaining to the collection of the check? A, B, C, D, E. Yes, now I am receiving good number of responses. All of the above is correct. All of the above, like good faith, without any fraudulent intention, without negligence, no alteration except for the date, and no other changes. In case of any other changes, a fresh leave is supposed to be issued. So all these things are correct regarding collection of checks. Next question. Identify the type of endorsement where signed without writing anything above the signature. Let's say you have signed, you have endorsed the check and nothing is written in that endorsement. What type of endorsement is that? Give the correct answer. Okay, only few have responded. Please do respond. Endorsement, obviously. Suppose somebody is signing without writing anything above the signature. It is a blank endorsement because no endorsement is done in anybody's favor. So it is a blank endorsement. Now, payee or endorsee cannot endorse it further. Suppose there is an endorsement already being done. Now the person who is being payee or endorsee cannot re-endorse it or endorse it further. It is a sort of which type of endorsement? Okay. Somebody has written blank endorsement. No. Blank was the answer for previous one. It is restrictive endorsement. That the endorsee has been restricted from further endorsement. It is restrictive endorsement. Please do read the line properly. Payee or endorsee cannot re-endorse it further. Which section of NIX says that if NI does not say whose it's for, you can transfer it to other by giving it to them. Like if it is not clearly mentioned on an NI, on a negotiable instrument, that to whom it belongs, you can transfer it to other by giving it to them just by the transfer. What is the correct answer? Section 47. Please do remember this. Section 47. Section 47. If NI does not clearly states that for whom it is, you can transfer it to other by giving it to them. It is clearly defined under Section 47 of NI Act 1881. Next, under which section of NI Act conversion of blank to full endorsement defined? Suppose there is a blank endorsement. Now you want to convert it into full endorsement. Under which section it is defined? Blank to full. Blank to full is defined under Section 49. No, A is not the correct answer over here. Yeah, A is certainly correct answer, but some people are writing 47. It is not 47, it is 49. Conversion of blank to full endorsement is defined under Section 49 of NI Act. Section 49. Blank to full endorsement conversion is defined under Section 49. Next question. Which section of NIX talks about the holder of instrument must present them to drawee for payment? The holder of instrument must present them to drawee for payment. It is compulsory for holder of instrument to present them to drawee for payment. It is defined under which section? Again, few responses I am receiving. A, E, D, B and C are remaining. On a lighter note. A, E, D, okay, maximum people are in favor of section 108. No, it is not the correct answer. The correct answer is section 64. Section 64 says that holder of instrument must present them to drawee for payment. Please do remember. Please do update yourself. Section 64 of NI Act tells that holder of instrument must present them to drawee for payment. Please do remember. Again, which section of NIX applies to offenses committed under Section 138? So here 2 points to be remembered. Offenses are defined in Section 138 of NI Act. And which section applies to offenses committed under Section 138? Like which section defines punishment against the offenses? 92, 91, 141, 11, 108. The correct answer is C, 141 over here. Not A, not E. The correct answer is section 141 is the section under which offenses committed under section 138 are defined. Like punishment under offenses committed under section 138 are defined. Next question. Which section of NIX is where enable time and drawer faces damages defined? Suppose the check is not presented for payment in reasonable time and the drawer who has drawn the check faces damages because of it. Then under which section it is being defined? Section 84. The correct answer is section 84. Suppose I have been given with a check and I am not presenting it on time, and because of that, the drawer of the check faced the damages. So it is defined under section 84, which is answer C. Please do read it. I'm taking a pause of a second. Please do read it. Where a check is not presented for payment in reasonable time and drawer is facing such damages, it is defined under section 84 of NI Act. So with that, we have come to the end of this webinar. These were few important questions as per your syllabus pertaining to various sections of NI Act. So I hope you got a deep insight of payment and settlement system, remittances, as well as NI Act through this webinar. You can post your queries in chat box. We can reply it later also. And this session would be available to you on Union Vidya portal. So thank you very much from my side. You can sign off, and all the very best for the examination from my side and from the side of ZLC Bhopal. Thank you.